Good afternoon, everybody. It's the end of the day in the Bob Ward trial out of Florida. This is a Central Florida case, a second-degree murder case, and the second trial for this particular defendant. He's facing second-degree murder charges related to the death of his wife. The defendant first said in a 911 call that he shot his wife. He later said it was an accident, that his wife was trying to commit suicide and that there was a struggle over the weapon, and that during that struggle, the weapon went off and ultimately shot his wife basically right between the eyes. The state is saying this doesn't make sense because the DNA on the gun is not the wife's DNA, etc. Now, the defense has sprung back and said not all the proper tests were done on the weapon. So other tests, specifically tests on the holster, could have proven that perhaps the wife did handle the gun, did take it out of a drawer, and did struggle with it with the defendant. So the jury has this case. We're waiting to see if they're going to have a verdict this evening. The jury is going to deliberate until 6 o'clock Eastern. We are also standing by waiting for opening statements in a Las Vegas, Nevada case that we're covering here on the Law&Crime Network. That's the Janet Solander case. It's a defendant facing 46 charges over abuse of children that were supposed to be in her care. Now get this, the defendant had previously written a book about how to deal with child protective services, and now she's facing these kind of charges. The accusations are incredible in that case. If you can conjure up the type of abuse in your head that may have occurred, chances are it's being alleged in this case. 46 counts. We're expecting opening statements in that case out of Las Vegas, Nevada, here on Law&Crime, possibly in about 45 minutes from now. So stand by for that one. In the meantime, Jonna Spilbor is here talking about all of the cases we've been covering. Good to see you again.
Really good to see you as well.
It's been a while.
Yeah, I know. I was here Monday. I was not here with you.
We're just not on together anymore. We just pass in the hallway.
So in the night.
Yeah, so we've got 3 trials that we've been covering.
Yeah.
We've got a death penalty phase coming up in the Donald Smith case. Yep. That verdict, 15 minutes. In a death penalty case, 15 minutes for that jury to say guilty.
And the jury got it right. Make no mistake about that. But we were talking off air. I am wondering if that is a record. Now, the jury this is what I imagine happened. They went back to deliberate. You usually take a vote to say, where is everybody? That vote must have been unanimous guilty. What's more to deliberate? Let's go back in.
The rest of the time, as many people have said on Twitter and whatnot, was just the jury sitting there making sure they filled out the forms properly.
Right,
That
exactly.
took, as one commenter said, that took 14 minutes and 59 seconds, and it took 1 second for them to say, I think this guy's guilty, and then everybody raised their hands. I don't think that I've seen a case in my life with evidence this strong. This was not a surprise.
No, it was not a surprise. Strong evidence. They put up no defense. I almost think this was what we call in the industry a slow plea, because the defense knew that they were going to lose, but it's a death penalty case, so maybe we will hear from the actual defendant in that phase of the case in an effort simply to save his life. But I think the defense knew full well that they were never going to get an acquittal or even a hung jury in the guilt phase.
Yeah, I mean, this trial was basically all about the penalty phase.
Yes.
So the prosecutor's clearly not going to plea away a possible death penalty for this guy in a state like Florida that's got pretty tough criminal penalties. Okay, so they're not going to plea that away. So of course the defendant's just going to turn around and say, well, I've got nothing to lose by going to trial, even though the evidence is this strong.
Right, precisely. And then remember now, the defendant made that sort of strange move a couple of days ago, I think when I was here on Monday, where they had planned, the defense attorney had planned to rigorously cross-examine the mother of the victim, and then the defendant, basically pulled on her shoulder and said, don't do that. So they didn't really cross-examine the mother at all. They put up no evidence at all.
I mean, what would they have gotten out of the mother anyway? We were sitting around here trying to suppose what may have been said, and I don't know where that cross-examination would have gone.
In my opinion, if he were going to try to establish a timeline where somebody else could have come in and actually committed this heinous crime, then they would have had to cross-examine the mother to try to establish the timeline. But for whatever reason, and I think actually, maybe for sympathetic purposes only, it was a smart move that they didn't, because you can't, listen, she is the mother of a dead 8-year-old girl. She is going to live with that decision, the decisions that she made for the rest of her life. You cannot. Don't make that any worse for this parent. Do not make that any worse. And at least they gave the mother a reprieve from having to relive that by answering their questions.
The only thing I could think of, and again, this is just me speculating, is perhaps the attorney was planning to question the mother about some of her initial thoughts, you know, should I trust this man or should I not? Because she really rattled that around. But again, where would that have gone? I mean, where would it have gotten this guy? Look, he's in the surveillance footage from Walmart wearing the same exact clothes that they caught him in the next morning. The clothes are dirty, they're wet, they find the girl's body in a muddy creek. I mean, you know, just everything lines up here. The van matches the van. I mean...
And you can clearly see them on all the surveillance videos that they had. And it was, you know, the creepiest part for me, we watched the surveillance of him kind of waiting around, sort of stalking the family a little bit in one of the stores, but it wasn't the one, it was like the dollar store.
General, yes.
And it just made me bristle. And if it's making me bristle, I imagine it made all those jurors bristle as well. They knew, they could infer what they inferred.
You had members of the jury drying their eyes. You had a medical examiner tear up on the stand. I mean, these are people who conduct autopsies, who have dealt with hardening themselves. Yes, they've seen it all. But this is one of those cases that does that to people.
Oh, absolutely. Absolutely. So listen, if we wanted to put some money on whether or not these jurors are going to spare this man's life, I see no reason to. He's got a long history. Now, I don't believe that came out during the guilt phase of the trial. This man is wired incorrectly. He's not redeemable. He has been a menace and a molester basically for his entire life. What's to spare here? So I don't think his plan to maybe spare his own life probably will not work. If I were a betting woman, I just don't see any redeeming qualities in this.
I mean, this jury's got to be sitting there hating this guy's guts.
So much.
Like, just, they loathe sitting there in proximity to this guy at this point, presumably. Okay, and now in the penalty phase, which begins Tuesday, they're going to sit and listen to probably all the other stuff he's done.
Right.
They're going to get oh yeah, this guy was a registered sex offender. He'd only been out of the can for a short time when he then perpetrated this crime.
Yeah, like 3 weeks. I mean, it really is disgusting. And like I said, no redeemable qualities for this person. So the plan to spare his life probably won't work. As a defense attorney, they have to go through those motions. He'll get an automatic appeal. And I don't think the jury's going to take that long to come back with a death verdict. Although I don't know how many of them are, they all had to be death qualified, but I'm not sure if they truly are death qualified, because, you know, you can only know so much when you're asking questions in voir dire.
Yeah, I mean, you can say, oh, I'll be able to consider the death penalty, even if you have a feeling in your gut that you don't agree with the death penalty. But a lot of times juries are afraid to dole out the death penalty in states which allow it, in situations where there might be one little murky piece of evidence, even if it's clear-cut for a conviction, but there's something where they turn around and say, you know what, it's beyond a reasonable doubt for a conviction, but there's something here that tells me either, as you put it, maybe the guy can get his act together behind prison walls somehow and he can stay there, or we just don't want to pull the trigger or push the red button or whatever the method is there in Florida, because what if, you know, something else were to come out? What if an appeals court finds a problem with the rest of the case? You know, this is not one of those cases, though.
No.
This is not one of those cases where doubt exists. This was proven, I think, to an absolute certainty that this is the guy who did this to this young girl.
That he absolutely did it. And the jurors should say to themselves, even if we do get it wrong, if we come back with a unanimous verdict in favor of death, then let the appeals court figure it out. That's not our job, right? Our job is we heard the evidence, and now we're going to hear evidence in the penalty phase. We're going to render our verdict, and then it's out of our hands. And I don't think they will be a bit uncomfortable. It was so much more uncomfortable to have to listen to this evidence. And I think the jurors probably have a real connection with the poor mother. I mean, really, this mother, I don't know. She's got to relive this every day. Like, if one decision had been just a little bit different, we wouldn't be sitting here talking about the death of her child, would we?
I mean, she's going to live with an eternal agony about this thing.
Oh, yeah.
And it's sad. as so many of these
horrible.
cases are, but this is sad on top of sad.
Yes,
on top of sad.
yes.
So I wouldn't be surprised if it's a short death penalty decision, unless there's a lot of true back and forth. So
I think we'll hear from him, though. I do think we'll hear from him in the penalty phase.
let's listen to a clip, and we'll be right back.
Just have a few questions for you. You indicated that you responded after, I guess you were having, you said lunch, but it's fairly late for lunch, I guess. Late lunch?
Yeah, when you if they
Gotcha.
it'd be my second meal, so I called it lunch.
It's your second meal. You call it lunch. It's
Yes, sir.
7:45 or 7:50.
Yes.
You guys take off and you're going down there, and you're going down there because the guy had called it in. In other words, that Mr. Ward had called in and asked for the police to come to his home, correct?
Yes.
Okay. And so were there 2 cars or 3 cars, police cars, that went to the scene?
There would have been 3.
Okay. There were 3?
Yes, sir.
Okay. And so when you get there, Mr. Ward's out screaming, "Hey guys, I'm over here." He's kind of waving you in, isn't he?
Yes, he does get our attention.
Okay. So you're trying to find out where the house is, either on GPS or whatever, but he's over kind of flagging you in and trying to get you to come to the house where he had called it in, right?
Yes, sir.
All right. Now, you indicated when you got out that your job and the job of the other deputies were to sort of secure, to make sure that there wasn't any kind of potential threat. So you take the precautions necessary, and you all get out and do your job, right?
Yes.
Now, so more than one of you is kind of giving instructions to Mr. Ward at that time, correct?
I believe me and Corey Legg were saying instructions at one point, yes.
Oh, so 2 of you are giving instructions. You feel as though maybe you were giving either more instructions or the loudest instructions. Is that fair?
Yes, sir.
Okay. Now, you indicated that while these 2 instructions were coming on, that Mr. Ward, you may say lie down, he was sort of backing up a little bit, or whatever seemed to be the instructions, he seemed to be a bit confused by it, correct?
Can you repeat the question?
Whatever instructions he was getting from you and Mr. Legg, he was a little bit, almost disoriented, non-responsive, because he's getting 2 instructions from 2 different people, right?
He was having a hard time following the instructions, yes.
Right. Well, either your instructions or Mr. Legg's instructions, he's got 2 people coming at him telling him what to do, correct?
Yes.
Okay. But in any event, down he goes, and then you go over, and then you handcuff him, correct?
Yes, sir.
Now, you were aware that this was called in by Mr. Ward regarding a death, correct? Or a shooting at the house where someone had, so were you aware of that?
Yes, we were told by our dispatcher that there was a shooting.
Okay. Now, so you indicated that he had kind of a smell a little bit of alcohol, right?
Yes, sir.
And maybe a little bit glassy in watery in his eyes?
Yes.
All right. Now, tell the jury what you did to test him for alcohol there. I'm sure you gave him a breathalyzer or did something to find out the level of alcohol that he may have had in him at that time.
No. I didn't do anything to test his alcohol level.
Did you have in your patrol car tests or breathalyzers where if you wanted to, you could have done that?
No.
So you did not have any breathalyzers in the car?
No.
All right. Do you know whether there was breathalyzers in the other 2 cars that were there?
There wouldn't have been. They're assigned to DUI units.
When he is down there, in order to preserve whatever evidence might be on his hands, did you bag his hands so that there might be a preservation of whatever might be on his hands?
No.
And do you know what I mean when I use the phrase bagging hands?
I would assume putting plastic bags over somebody's hands.
You sounded like you're asking me a question. My question is, do you know what it means when the phrase says to bag a hand or bag hands?
That's never been a part of any type of policy we've been taught or any type of investigation that I've ever been a part of.
Okay, so you've never been in a situation where there's an investigation of a shooting and the victim or someone else might have their hands bagged in order to make sure that whatever evidence is on the hands could be preserved.
I've never seen that.
Okay. What we do know is you didn't do that.
Correct.
Okay. Did you, now you indicated that he had his glasses in his hands, right?
Yes, sir.
And you indicated that he had a phone, a BlackBerry phone, is that?
I believe it was a BlackBerry, yes.
Okay. And was that what he was using to coordinate with the 911 call to coordinate the arrival of you gentlemen?
It would be a guess if I answered that. I think so.
All right. When he got down on the ground, what, if anything, did you do with the phone?
He put the phone down on the driveway during one of his couple of trips back and forth. Like I said, was still holding what turned out to be glasses in his left hand. Once he put the phone down, he moved far enough away from it that when I put him in handcuffs, I moved him away from the area that was still dangerous and left the phone where it was.
So you didn't touch the phone, correct?
Correct.
Because you, may I assume you didn't touch the phone because you believed it to be potential evidence in the case, and you didn't want to put it, to take it into evidence at that time. Is that right?
Right.
So you leave the phone there for someone else to come and get and put it into evidence, correct?
Correct.
Now, with the glasses, that's a little bit different because he indicated to you that he couldn't see without his glasses,
Yes, sir.
and that's when you gave his glasses back to him, correct?
Correct.
Now, you indicated you saw some dark features on the back of his shirt. You know, you don't know whether it's wine or some juice, or you don't know what it is, do you?
No.
Okay. And so, and you didn't do any investigation on his shirt, I assume, to
No, sir.
determine what it was. Your job was to get him safely in a position away from the house, and that would have, I assume, been in one of the cars?
Yes, sir.
All right. And then that's when you decide that it's time to go inside yourself, correct?
Yeah, with a group of people once we've secured the
Now,
scene.
were you the first individual in to the master bedroom where Mrs. Ward was?
I don't remember.
So the first group that went in, that would have been you and Mr. Legg and who else?
I don't remember if Deputy Legg went inside. I don't know if he had something else he was doing outside. I know I went inside. There was a sergeant. I think Greg Rickman went inside. I don't know if he was a corporal or sergeant at the time, but there was a Doug Cornwell that went inside. There was a handful of people that showed up after the fact that we assembled a team based on the size of the house that we felt we could safely maneuver that went inside.
Who was in charge on the scene of the law enforcement group?
It would have been myself, Deputy Legg, and Deputy Bagley until some of the sergeants showed up, and then they took over command of tactical operations, if that's what you're asking.
So who took over command from you? Who was the next person that showed up to take command of the scene?
I don't remember exactly. All those people that I just lifted off had rank at the time. They were corporals or sergeants. I don't remember who showed up first.
Okay. But whoever outranked you, or someone who outranked you, then took over the scene, and you were excused from your duties in terms of being in charge of the scene.
Correct.
Now, when you went out, you said you went out in the patio, correct?
Yes, sir.
Now, you didn't see anything on the patio. You didn't see any turned over furniture, did you?
I don't think so.
You didn't see any turned over tables or turned over chairs, did you?
No.
That's all I have, Your Honor.
Redirect.
Now, Deputy Mandarano, Do you arrest people for being drunk at their own home?
No, sir.
All right, and when you have a shooting investigation like this, is testing the sobriety of an individual in their driveway the goal of your response?
No, sir.
Nothing further, Your Honor.
That was one of the responding officers in the Bob Ward case out of Central Florida. We're calling it the millionaire murder trial because this defendant was from a very wealthy community, extremely wealthy community in the Orlando area, and he's facing second-degree murder charges. Jonna Spilbor is still here with me, and Jonna, this, isn't first-degree murder.
Nope.
So the state has a lesser burden to try to prove what happened here. It's probably wise for the state to go after that slightly lesser charge because the defendant has tried to posit that this might have been an accident.
Oh, I think this entire defense, if you had to sum it up in 2 words, is a reasonable doubt defense. It's not that the defense is able to say with 100% certainty that she most certainly did try to kill herself, but I think the defense was able to say to the jurors and impart there that it could have happened this other way. And that's really what you need for even one juror to say, I'm not convinced that the defendant is guilty beyond a reasonable doubt.
I agree with you. Okay, it is a reasonable doubt defense, but it's really helpful when you have a reasonable doubt defense, and I've been saying this all along, to also have an alternate theory, an alternate timeline, or an alternate set of facts. Hey, it could have happened this way.
Right.
And their investigation backs a lot of it up, but not all of it up. So I think that it's a reasonable doubt defense coupled with an alternate theory.
So isn't that, and you're right, but doesn't that fly in the face of our system of jurisprudence, right? Because you're presumed innocent until proven guilty. Not our job as, say, defense counsel to prove that you're innocent, but it sure does help.
It sure does help. Yes, exactly.
I mean,
yeah, I mean, it flies in the face of the presumption of innocence, which is great. But, so the defense can turn around and argue presumption of innocence, reasonable doubt, and oh, by the way, this is the way we really think it went down. That's way better for the defense to do that than the defense to just get up there and say, oh, this test wasn't done, and then they try to make the state's case look like a brick of Swiss cheese without saying that there's another flavor, there's Colby Jack over here, that, just look at the holes in the state's Swiss cheese when we've got some, you get what I'm saying?
Absolutely. And I think this defense team did a good job of that. What I was impressed by the expert testimony that the defense brought forth in an effort to show that, wait a minute, the wife was not a stable person. She did suffer from depression. It is plausible that she was trying to kill herself, and that's what led to this battle over the gun that ultimately ended up going off and killing her. That's a plausible explanation, and jurors want plausible explanations. They want to solve the mystery, always. It's really not their job to do it, but they want to. And the defense gave them a lot of fodder to do just that.
Exactly. And not only do they have this alternate theory, but there is the pharmacological issue of the combination of alcohol and antidepressants in the wife's system. Now, we all know you're not supposed to mix medicine with alcohol, and maybe this is a smoke and mirrors defense. And I know some people could turn around and we can probably get into the scientific debate about whether or not it is a smoke and mirrors defense or not, but for a lot of jurors, it's at least plausible that even if the wife wasn't contemplating suicide either regularly or even in that moment, that something just wasn't connecting properly with that combination in her system, and it could add up to a tragedy.
Absolutely. And I think even if they can't convince all of the jurors, in a case like this, if they convince 1 or 2, now you're looking at, because this is the second go-round for this defendant, and suppose there's a hung jury here, suppose there's another mistrial. Now you've got a prosecution who's got to say, do we want to do this for the 3rd time? So in a sense, a hung jury in this case might be the equivalent of an acquittal. Only because, like I said, this is not his first rodeo.
Yeah, what are they going to charge him with? I mean, knock it down to an even lesser charge, try to turn around and lump it into a manslaughter charge. I mean, even then,
I would be surprised.
A 3rd trial.
I'd be surprised if the jurors weren't instructed on a voluntary or involuntary manslaughter. What if there was recklessness involved when they were going after the gun and then it discharged and killed? And I could see that as an involuntary manslaughter if the jurors were allowed to find as much. But I didn't hear all the jury instructions, so I'm not certain.
Neither did I. Now, normally there is that chance, but this is one of these cases where a defendant might not want to go with that because there is a
the all or nothing, yes.
The all or nothing case, because sometimes it's easier to try to box the state into a pretty narrow, area and say you're going for everything, and that's not what this is.
This would be a great all or nothing case for this defendant for that reason, because if it's all or nothing and you get 1 or 2 or 6 who can't decide on this, I think it's as good as an acquittal for this defendant. Listen, he's no spring chicken. He already served a few years in jail. This is his second go-around. The prosecution is going to have to decide, do we want to spend the time and the resources to do this for a third time if, in fact, they don't come back with if they come back with a hung jury?
Yeah, I think that the state would have to seriously question how much more it wants to put into this case. Okay. And look, one other sort of interesting little quirk about this thing is we saw a lot of attacks, especially early on in the case when we were hearing from the first responders, well, wait a minute. The defendant had been drinking. Did you check his blood alcohol level to see whether or not he was even coherent when he said, I shot my wife? And the response back, I think, was interesting. The response back was, we don't even have breathalyzers in all our cars. This is probably a police department in an extremely affluent community that does what? Speeding tickets? They don't usually do murder investigations.
Sure.
They don't even have breathalyzers in all their police cars.
That is a little crazy. And I could also see where a juror could infer, in the heat of the moment, you're fighting with your spouse, a gun goes off, you had it in your hand at some point, and when you call the police or you're speaking to the police, I shot my wife, and excitedly, whether you actually did it intentionally or not, that easily could fly out of somebody's mouth. And I think a juror would be inclined to believe that. You know what they do. You're not supposed to, but jurors are going to go back in the room and think, how would we have done, what would we have done differently? Could this have happened to us? And try to put themselves in the scene to get to the bottom of what happened.
It seems that the DNA on the gun is going to turn into a huge part of this because the state's theory is that, well, the defendant's DNA is on the weapon, but there isn't enough of the wife's to really suggest that she was holding it. Well, then the defense jumps back and said, and I think the defense did a great job with this case, jumps back and says, well, you didn't test the holster.
Right.
Okay, well, was she barely holding the gun? And look, the absence of DNA doesn't necessarily mean someone didn't handle something. It just means that the DNA didn't transfer.
And it's very difficult to prove a negative. And a lot of times defense attorneys are called upon to do just that. But what it does do is it puts more evidence in the side of the defendant's side where they're trying to show that there is reasonable doubt. You didn't do the testing. The absence of DNA doesn't really mean anything. Oh, and plus, by the way, we have this plausible other theory over here. So they really did try to wrap it up in a nice, neat little package for this jury.
It was good defense advocacy, good prosecution advocacy as well. But, there was actual defense advocacy in this case, as opposed to the Donald Smith case where we just haven't even seen much of it yet.
Yeah.
But look at the factual scenarios. Totally separate cases. Smith, I don't think there was any doubt in anybody's mind that that guy was guilty.
Right.
Ward, what really happened there? We're still here debating it.
Yes, exactly. Two totally different defenses because there are two totally different cases. And I mean, just jumping back to Donald Smith for a minute, I mean, you really had an instance there where there was absolutely no defense put on at all. Which is
no closing argument at all by the defense.
Nothing. Which is what we call in the industry a slow plea, meaning they were not able to get an agreement that he would plead guilty to everything and in exchange for life in prison without the possibility of parole. Wasn't able to do that. So as we were discussing previously, you might as well, all right, then I'll go to trial and see what happens because he doesn't have anything to lose. Nothing to lose. So, and that's the tactic here by that defense team.
I agree. Let's continue reviewing some of the previous testimony in the Bob Ward case out of Florida. The jury got that case a short time ago. The jury is going to be allowed to deliberate until about 6 o'clock Eastern. We're going to be monitoring the situation to see if there's a verdict. But as we've been discussing, this might be a case that takes a lot longer than 2 hours to settle in the minds of the jurors. We'll review testimony on that as we prepare for opening statements in another case we're covering here on Law and Crime. That is the Janet Solander case out of Las Vegas, Nevada. This woman was originally charged with more than 40 counts of child abuse and related charges, including sexual abuse of children that were in her care. Now, ironically, she had written a book about how to deal with child protective services before these entire charges were levied at her. It's been cut down to about a little bit more than a dozen charges, as I understand it, but that trial is set to kick off with opening statements at about 5 o'clock Eastern. We will be carrying it here on Law and Crime. In the meantime, back to the Bob Ward case.
All right. And when did you first begin working for the Orange County Sheriff's Office?
For the Sheriff's Office, my hire date is 10/6/06.
So back on September 21st of 2009, you were with the Orange County Sheriff's Office.
Yes, sir.
And where were you patrolling that and during that date and time?
I was assigned to Sector 3 Road Patrol, which is West Orange County, Dr. Phillips, Wyndham area.
Now, at around 7:45, 7:50, did you and other deputies that you were out to dinner with receive a call for service?
We did.
All right, and what was that call for service?
That was a high priority Code 3 call, and it was for a shooting.
Now, how did you respond to this Code 3 call?
How did I respond?
Yes.
We left dinner and went to our vehicles, lights and sirens, pretty much down to, it's a gated community, up to the gate.
All right, and then you say up to the gate. Why'd you cut your lights and sirens at the gate?
Obviously, if we're running lights and sirens, we draw a lot of attention, so we didn't want to draw any more attention. And also, we were going to have to talk to the guards at the gate, and with the siren in the background, it wouldn't be feasible to have a conversation.
Now, did you enter into Islesworth?
We did.
All right, and what position in the cars were you? First, second, third?
To my recollection, I believe I was a third vehicle.
Now, when you arrived at the residence, what did you do?
The three of us pretty much arrived together, so it might be a convoy, if you will, and exited my vehicle. The other two deputies had exited their vehicles and had approached on the right-hand side, and I stayed behind as a cover officer.
Okay, now, when you say you remained behind as a cover officer, what exactly are you doing?
I employed a rifle because of the location. The residences are spread far apart, and the houses are generally larger than average, in my opinion, from my experience. So due to a distance, there are certain times where the tools or weapons we use are more feasible for longer distances. So I provided basically lethal cover, if you will, while the other two deputies approached the residence.
Now, while you were providing cover, were you able to see an individual in the driveway?
At first, no. But eventually, as they approached, the dispatcher, I believe, alerted us that the suspect could see us.
And then were you able to see the individual?
Yes.
Now, as you're providing this cover, did you observe the other deputies giving commands to the defendant?
I could not see them, but I could hear them.
Okay. Okay, so then I'm just a little confused and curious, actually. So how are you providing cover if you can't see them?
Okay, I'm covering the house. Like I said, it's a very large residence that's in there. And to my estimation, since we were still on the street and the house is set back further than the street, almost if it has its own cul-de-sac, I estimated it to be 50 to 75 yards, so which is greater than the distance of this courtroom. They used different methods of concealment to conceal where they were. Obviously, we wouldn't walk directly straight up in a straight line. So I was covering, waiting for somebody to come out of the house while they were approaching in another direction.
Gotcha. Okay, so you're not actually pointing your gun at the defendant while he's talking to the first two deputies?
At the initial approach, I did not see the defendant, and my other deputies were using concealment where people couldn't see them, obviously. So I could hear them, I knew where they were, but if I focused on them, I couldn't focus on the house.
All right, now you could hear them giving the defendant verbal commands.
Correct.
All right, and were they both giving commands or just one?
No, Deputy Mandarano was giving instructions.
All right, and could you observe any difficulties with the defendant complying with those commands?
At that time, I could see the defendant. He did have his hands up, and I do recall Deputy Mandarano telling him to drop what's in his hands, which obviously alerted me because I was so far away that I could see the defendant, but not what's in his hands. So that gave great cause for alarm for me. And then, since only one officer or deputy gives the commands, it would be less confusing for the defendant, but he did not immediately comply, no, sir.
Now, once he was taken to the ground, where was he placed?
I was still in cover once they made contact, once they made the approach, if you will, and then went what we would call hands-on with the suspect or the defendant. I left my position and started advancing towards the house, still looking to see if there were other suspects to come out of the house.
Now, did you have any contact with the individual they took into custody?
Once the defendant was on the ground and they had applied the handcuffs to him and were patting him down for everyone's safety, I remember I did ask him a couple questions, so I was within earshot of him.
And what questions did you ask him?
I believe I stated in my report, but I'm just going from the recollection. I would have asked him consistently, is there anybody else in the house? Are you alone? If there's anybody in the house, where they are.
Your Honor, I object. If he remembers what he did, he can say so, but to say I would have asked him.
You object?
I object.
Thanks. Sustain.
Now, did you eventually make entry into the house?
We did.
All right, and when you made entry in the house, where did you go?
From the front door, I went to the right and up the stairway.
And did you eventually spot the victim in a bedroom?
Yes, as we were making approach up the stairway, out of my peripheral vision to the left-hand side, I did observe a hand and then an arm as I went up the steps. So as you could see, if you could imagine, walking up this way, and as you walk up, more and more of the view comes into play, if you will. So I believe at the top of the stair, I was able to see a head right on the arm part and then all the way down to the hand.
And what did you do when you saw somebody laying down, I'm assuming?
Yes, the victim was on the ground.
All right, and what did you do?
Gave verbal commands to the victim. You know, can you hear us? Are you okay? Do you need help? Look for any kind of signs of life so we could immediately go to the victim and render aid.
Any response?
No response.
All right, and when you got a full picture of what you saw initially was a hand, any signs of life?
No, sir.
Now, when you were in the bedroom, did you notice anything on the nightstand right near where the victim in this case was laying?
I did observe what I believe to be a gun holster, black in color, on the nightstand.
All right, and did you collect that holster?
No, I didn't.
All right, and why didn't you collect the holster?
As a road patrol deputy in a crime scene such as that, it's not my job to collect evidence. We have a special unit that does that.
Just one moment. Nothing further, Your Honor.
Frost?
Good afternoon. Just a few questions. When you arrived, you said that you were sort of in the back with the rifle, providing some cover for your colleagues, correct?
Okay, I was at the back of my vehicle, yes, sir. But if you say the back, you're going to have to specify for me where you're the back you're
You
talking
were
about.
farther away from Mr. Ward than the other two officers, correct?
Initially, yes, sir.
And so, who were the other two officers?
Deputies Legg and Mandarano.
Okay, now Deputy Mandarano, was he giving commands?
Yes.
And was Deputy Legg giving commands?
I don't recall hearing Deputy Legg speak.
But, so you don't recall that? You don't know whether he was or wasn't?
I can tell you with certainty that Deputy Mandarano gave commands, and it was his voice that I heard. If Deputy Legg gave commands, I didn't hear them.
Oh, I see. All right. Now, you go inside the house. You go up to the room. You see Mrs. Ward on the floor, correct?
I did.
And one of the first things that you see that catches your eye is a black...
Welcome back, folks. We've been reviewing testimony in the Bob Ward case, and it looks like there's activity in the courtroom yet again. The jury's been deliberating for probably about 45 minutes. Let's go to the courtroom live and listen in. The attorneys talking back and forth about some evidence in the Bob Ward case. The jurors have asked not only for the weapon, but it appears that they've also asked for some kind of a list of evidence. And the list that the court has includes items that weren't actually submitted. So it looks like they're going through the process of whittling that list down to present the jurors with a list of evidence? I mean, is this just a mnemonic tool so that jurors can go through it and remember everything that was been submitted?
You know, I guess they're doing a little housekeeping here, because the one thing that concerns me is the jurors asking for evidence that's not evidence, right? It's not evidence if it wasn't admitted into evidence. So we have to make sure that the jurors don't get anything that wasn't actually admitted during the trial, because if the defendant is found guilty, obviously that would be a major ground for appeal there.
Yeah, they want to make sure that the jurors aren't even getting wind of anything that wasn't submitted. So, of course, this might be a little bit of a lengthy process. But we were in the midst of reviewing, right before we cut back in to bring you the live court action, we were reviewing the toxicologist testimony. And look, this was a big deal, whether or not these antidepressants could interact with the alcohol, or whether either one alone could have affected the victim's motor skills or decision-making process to the point where it would give some validity to what the defendant has argued happened here.
I mean, and they had expert testimony to support that theory, but that's almost something that most jurors could apply common sense to, unless they had jurors that were teetotalers and have never had a drink in their life, for example. But this is really something, depending on how, I guess what the experts could help with was how drunk was the victim in this case, because that would sway a jury.
Yeah, let's listen back into court. It looks like they're back into session.
All right, let's send it back to the jury room, please. We're back off the record.
This process is grinding on of sending this list apparently back to the jury, and we were talking about the toxicologist. I agree with you. This is something that a lot of jurors can just sit back there and say, hey, look, we read the warnings on any medication we've ever taken over the counter, been prescribed. They all say don't mix it with alcohol, or at least virtually all of them say that. And there's a reason for that.
Yeah, there's a reason for that, because there could be this synergistic effect, number one. Number two, if anybody's ever imbibed on that jury, even if you don't combine other drugs with alcohol, if you drink enough alcohol, I mean, why do we have DWI laws? It's, after a certain point, you no longer have motor skills, proper motor skills. You no longer have the ability to make decisions properly, because that's what the effect of alcohol on the brain. That's a key component for this jury. And like I said, they bolstered it with expert testimony, but it's kind of the type of evidence that you just have to apply common sense.
You know, might the jurors just turn around and say, well, you know, the state's expert said these things were in her system, but we don't know what kind of tolerance she had, so we don't know how ill the effects would have been. Could they just turn around and say, well, it's a maybe, but it's a nothing burger? Or could they turn around and say it's reasonable doubt? Or could they do both?
Yes and yes. Yes and yes. So that, you know, jurors are allowed to take inferences from the evidence that they get. And that's going to be a key component here. Which side are they going to come down on to that particular issue? Because it's a big part of that alternate theory that the defense presented here, right? Because if the victim had her wits about her, if she had her faculties about her, then that alternate theory doesn't work anymore so much. So it's something that they're really going to have to seriously consider and juxtapose against the prosecution's theory, which is it was a nothing burger. That didn't matter, because that's not what happened here.
And again, this is a case where there are so many stories that could be spun out of the facts. We know that there were empty wine bottles. We know that there was a small wine spill. We know that there was, I think it was a broken wine glass or something of that nature. Right. Now, is this evidence just people were drinking and falling down? Or, as the state has tried to characterize it, is this evidence of some kind of a fight? Which one is it? You know, I mean, again, facts, we know the items were there. What do they mean? Each side has been able to tip the scale in its favor depending on who you listen to.
What's so interesting about this type of evidence is it's not the type of evidence that would lend itself for the jury to say, this is a cut and dried issue. So you could have 6 people leaning toward, I believe this alternate theory that the defense put forth, and you can have 6 people saying, me not so much. And what is that going to get you at the end of the day? It's going to get you a hung jury.
Probably going to get you a hung jury, or you might have, depending on who's strong-willed and who's not. If I'm to channel the jury consultant, Alan Turkheimer, who joins us frequently here, he turns around and oftentimes says, some of this comes down to psychology. If the people who are on the fence are really articulate, have really strong wills, they might turn around and say, okay, you think he's guilty. I'm not sure that I believe the story. We have to acquit because it's not beyond a reasonable doubt. There are doubts sitting here and we can articulate the doubts. And if that argument carries the day, gosh, we could see an acquittal.
And let's not forget that the defense took great pains to make sure it went through what is reasonable doubt, ladies and gentlemen of this jury, to make sure that they can take all those facts and apply it to the law and come to one conclusion. Of course, the defense wants an acquittal, and it is possible in this case. But I say the nature of this evidence is such that if they do get to an acquittal, it's not going to be a straight line to an acquittal. It's going to be a whole lot of deliberating and this whole plethora of evidence that the jury has in front of it.
I don't have a fly on the wall in the jury room, but I think it's pretty clear that the jurors are probably having a discussion just like the one that we're having right now, trying to sort this out.
Right, trying to read their own tea leaves. But, you know, they've got the biggest piece of evidence in with them, or they're going to in a momentarily.
Yeah, we don't have the gun. They have the gun.
Yeah, they have the gun, and that is a critical piece of evidence.
Exactly. Let's continue our review of the toxicologist testimony. This is a really key area that jurors may likely hone in on.
If anything, can you tell us as a forensic toxicologist about the relationship of those two numbers from those two different places?
So the concentration that we most rely on in terms of effective alcohol in the body would be the blood alcohol concentration. The vitreous is a sample that's run primarily for confirmatory purposes, to make sure that there wasn't a mistake in collecting the samples or analyzing the samples in the laboratory. So in this matter, we have a blood of 0.11, actually 0.113, and a vitreous of 0.110. They're essentially the same. So obviously there is confirmation in place to ensure that the results are correct. I really can't say any more with regards to what those values mean exactly.
Okay. It's just my understanding that sometimes when those numbers are grossly different, people can give opinions perhaps about how recently it was ingested and whether it was still on the uptake or the downtake. Am I offbeat on that?
Sometimes. So, and it gets a little bit complicated, so I'll just demonstrate it for you.
Reader's Digest version.
Yes, it will be quick. As the blood alcohol concentration increases, so does the vitreous, the eye fluid alcohol concentration, but it lags behind. It may lag behind in terms of time frame by a half hour, an hour. We don't really know exactly how long because you can't do studies in living people, of course. So as the blood alcohol concentration is increasing, the vitreous is following behind like a tail on a dog. There'll be a time where the alcohol concentration in the blood peaks and then it's going down. So the vitreous continues to follow behind. So when alcohol is being absorbed in the body, the vitreous falls below the blood typically. And when all the alcohol has been absorbed, then the vitreous is falling behind like this, but it's higher. In this case, we have 0.11 and 0.11, so it's about the same. So it's somewhat difficult to see exactly where she was in terms of absorption and elimination of alcohol.
Is it fair to say that 3,000th of a gram per deciliter is 3,000ths of a gram per deciliter, or 100 milliliters, right?
Yes.
Relatively plateaued?
Yes.
Okay.
They're the same.
Now, can a forensic toxicologist or a medical pathologist or anybody say, based on somebody's blood alcohol level alone, what particular behaviors or effects a particular person would be under from that alcohol?
No, there's a continuum of effect in a person, and that continuum in each and every one of us is different. So the way that I react to alcohol will be different than the way that you react to alcohol. So while we can say that Ms. Ward's normal faculties were impaired by alcohol at the time of her death, we can't say exactly what and how those faculties were impaired. Were they impaired to only a small degree or moderate or significant degree? Can't really say.
And can one, through continuous and repeated use of a substance like ethanol, build any sort of tolerance to the ethanol?
Yes, and that's one reason, a physiologic or pharmacologic reason for why we can't tell you exactly what the effects were at that moment, unless, of course, they were recorded one way or another, because an individual will obtain tolerance to the substance. So in this case, if there was repeated ingestion of alcohol over a period of time, she may be tolerant or acclimated to the effects of the alcohol. Doesn't mean that her faculties are not impaired. So pharmacologically and behaviorally, she is impaired, but maybe not as impaired as someone who has no tolerance.
Okay. But regardless of the inability to say with any specificity what any particular person at any particular place and time would be feeling from the effects of ethanol, it is a central nervous system depressant.
Yes.
And does that affect one's gross motor skills and coordination?
Yes, and that would include the ability to walk or even talk.
And isn't that even like in the jury instructions for DUI, the normal faculties of talk, walk, make decisions, do ordinary daily things?
Yes.
How about fine motor skills, like things that require your hands?
Those can also be affected at higher concentration of alcohol. Again, in this case, I can't say for sure, unless, of course, there was some sort of recording. Like in a DUI, we would have field sobriety exercises that might be recorded, so you could see and evaluate that. Of course, we don't have this in this matter.
Okay, okay. And balance?
Yes, balance.
Okay. Let's talk about a substance called trazodone. Are you familiar with that particular substance?
Yes.
And what is that particular substance?
Trazodone is an old-fashioned antidepressant medication. So 30, 40 years ago was used as an antidepressant. It's more commonly used today as a sedative or sleep aid. That's one of its side effects, is it makes you sleepy. It helps you sleep.
And what particular class of drug is this drug?
Well, technically it's an antidepressant, but it's also a sedative.
All right. And how does an antidepressant work, like trazodone, that particular antidepressant?
All antidepressants work in the central nervous system. Again, we're speaking to the brain. So it has an effect on neurotransmitter levels. So the trazodone drug, which is, as I said before, has been around for decades, was used as an antidepressant, but its side effect is to be sleepy. It has other side effects, particularly when too much is consumed. So it's fairly easy to overdose on trazodone. It's not a drug that's prescribed today to treat depression. There are better drugs and more safe drugs than trazodone.
Is it still continued to be prescribed for what we call like not the intended manufactured use?
For sleep, yes.
Okay. And was there any trazodone found in the toxicology report for Mrs. Ward?
Yes, there was.
And at what level?
The concentration is 0.082 micrograms per milliliter.
And in the world of toxicology and forensic toxicology and the practice of medicine, has anybody developed like a therapeutic range for this drug trazodone?
Yes, there is a therapeutic range. Now, when you refer to a therapeutic range,
please explain that.
Yeah, that's a therapeutic range or range of blood drug concentration that causes a therapeutic response in the individual. These therapeutic concentration ranges don't necessarily correlate to what you would find in a postmortem. I think we'll talk about that later. So we have to be careful when we apply therapeutic ranges that are designed for interpretation of blood drug concentrations in living people compared to someone who is deceased. But we do have a living therapeutic blood drug concentration for trazodone.
All right, and her level, where does that fall within the living person therapeutic range for trazodone?
Well below the therapeutic concentration range.
And
Just remember that's in a deceased blood sample versus in a living person. But it's a concentration that I would expect to have almost no effect.
Okay, and I was just gonna ask you, with this drug, trazodone, is there any particular way for you or anybody else, like a medical doctor, to say what side effects, if any, that particular person or intended effects would have been under from the trazodone?
Well, based on my decades experience in the field and assessment of trazodone in hundreds of decedents, I would say this has no effect.
Okay.
And this may be consistent with taking trazodone the night before, and this is what's left over as a residual the following day.
And so hypothetically, if her time of death was around 7:50, 7:55 p.m., I know you just mentioned perhaps taking it the night before. With that more narrow time frame, does that fit with what you just answered?
Potentially, yes.
Okay. Now, you were talking about how some classes of drugs, there may be a different level post-mortem, which is after death, versus ante-mortem living. Is trazodone one of those such drugs?
Yes. Each and every drug has the potential to change during the post-mortem interval. That's the interval from that instant of death to the time of autopsy. So that because of that potential post-mortem change, we have to interpret blood drug concentrations with great caution. As I mentioned before, we have a therapeutic concentration range for trazodone, but it doesn't really apply to a decedent, certainly not in a vacuum. So you can't just look at the concentration and say, aha, that is the cause of death. Now, there are circumstances where blood drug concentrations are very high, and then we can clearly assume that that is the cause of death. But when the concentrations fall within these typical concentration ranges for a postmortem, they're not necessarily or immediately to be assumed to be a cause of death, or even to have any real effect on the individual's behavior or performance.
And what is the physical mechanism that is going on in a body to cause this post-mortem redistribution of a drug such as trazodone?
So there are many possible mechanisms of post-mortem drug redistribution. That is the movement of drug to and from tissue, to and from the blood vessels, to and from muscle. So even to and from the stomach, if there's drug in the stomach or the GI tract. So part of the mechanism is easy to understand because we learn about this in high school, diffusion. So concentration goes from high to low, and the drug that's in the blood will migrate from high to low. So if you have a tissue or a vessel where there's high drug concentration, it may transfer through the tissue, through membranes, to someplace that's low until there's some sort of equilibrium there. That's fairly easy to understand. We also know that some drug has particular affinity to specific tissue in the body. So we know that some drugs have a high affinity for cardiac tissue in the heart. So these are just two of many possibilities that cause redistribution of drug. So in the end, really, the interpretation of a blood drug concentration has to be interpreted with great caution.
And does it matter where the blood sample is drawn from that is being tested to talk about this issue of post-mortem redistribution?
Yes, generally, but again, there's not a hard and fast rule to say one is definitely better than the other. We prefer blood samples that are collected from the periphery, as far away from the chest and even the abdomen. So blood collected from the femoral artery or vein, or blood collected in the arm from the subclavian are ideal. In some postmortems, that's not possible, but when possible, that's the best sample, least subject to redistribution because it's furthest away from the drug depot that's in the central compartment of the body.
And in this particular case, if hypothetically her postmortem blood sample that was sent to the lab was drawn from her femoral artery up near her bikini line, is that considered peripheral?
Femoral artery blood is peripheral.
And in peripheral blood, is this phenomenon of postmortem redistribution completely absent, or what can you say about that issue?
It's not absent. So there's no way, unfortunately, to freeze the body as is at the moment of death and prior to the autopsy. So these changes occur, and they occur with great frequency, and there's no possible way to measure it. So I can't extrapolate backwards in time to the time of death based on a blood drug concentration from the femoral artery, for example, in this case. So again, caution is advised.
And I know you said that the trazodone levels in this case were pretty insignificant to the point that you could opine that there was no effect on behavior. But hypothetically, if there was, is there any relationship between ethanol and trazodone? Would they be like an additive effect that add on to each other? Or would they subtract from each other, or something else? Can you explain?
Yeah, something like additive, but it's not possible to do 1 + 1 is 2. But alcohol is a central nervous system depressant, and as I said, the trazodone is a central nervous system depressant as well. So you might have the combined effects of the two. Whether it's exactly additive or more than additive, I can't really say.
Okay. Now let's talk about citalopram. Are you familiar with that substance?
Yes.
And I believe that it comes under a couple different brand names, but are you familiar with a brand name variety of it called Celexa?
Yes.
All right, what can you tell the jury about this substance, citalopram, that comes in the form of Celexa?
Citalopram is also an antidepressant, so the effect on the body is similar to trazodone, but it is more effective, but it's also more safe. So the newer generation antidepressant drugs that were introduced 20 and 30 years ago, these are called serotonin reuptake inhibitors drugs, or SSRIs. They are more safe, it's more difficult to overdose with these drugs, but you still have the antidepressant effect.
And just briefly, what is serotonin and what is SSRI?
Yeah, so it's a selective serotonin reuptake inhibitor, SSRI. Serotonin is that neurotransmitter in the brain that makes us feel good. We're less depressed if you have normal levels of serotonin.
And so how does this drug work to make people who are less happy more happy?
Because it stops the reuptake of the serotonin in the brain, in the nerve system, in here.
All right. So for me, Friday is my day to take the garbage and the recycling bins out. So are you saying that our body has this process where you have serotonin and it needs to get taken out to the curb every so often, so to speak? Is it something like that?
Well, there's a constant process of production of serotonin and a turnover and reuptake of the serotonin in the neurotransmitter system. So what this drug is, it slows down or prevents the reuptake of the serotonin, so you end up with increased serotonin in the brain, and therefore less depressed. That's the goal.
Okay. And besides being used as an antidepressant to treat depression, which is a sad mood, right?
Yes.
Does it have any other uses?
Not really. Citalopram is principally an antidepressant drug. Some physicians may use it to stabilize mood, so maybe it's not necessarily a depressant type mood, but it could be used or maybe termed as a mood stabilizer. It may also be used in a patient who's being treated for anxiety, but it is, by definition, an antidepressant drug.
All right. And in the blood sample that was drawn from Mrs. Ward and sent off to the toxicology lab, was there a reported value for citalopram in that blood sample?
Yes.
And what was that level according to the lab?
840 nanograms per milliliter.
And just really quickly, what's a nanogram? How does that relate to grams, micrograms, and then is it milligrams? as we go down?
Milligrams, then micrograms, nanograms. It's a figure. You can't see a nanogram, but we can measure a nanogram. We can even measure a picogram, which is smaller than a nanogram. We have very good sensitive instrumentation to be able to measure down that low.
Okay. Now, same question as I asked earlier about trazodone. In the world of toxicology and forensic toxicology and the practice of medicine, has there become an accepted range for a therapeutic value for somebody who's alive taking citalopram?
Yes, there is.
And what is that range?
The range in living persons is 9 to 200 nanograms per milliliter.
All right, so let's talk about that. 840 is more than 4 times, almost 4.5 times 200 nanograms. Is there any post-mortem redistribution phenomenon with this substance as you previously described with trazodone?
Yes. So citalopram is a drug that will redistribute.
And when a blood sample is taken from the femoral artery, is that phenomenon of post-mortem redistribution still a possible thing?
Yes, every time.
So how about taking it from the heart as opposed to the femoral artery? Can you discuss that, compare and contrast?
The likelihood of redistribution, if you have a specimen from the heart, is greater than if you have a specimen from the femoral artery, in most cases. But there are cases where the femoral is more likely to redistribute than the heart. So there's no hard and fast rule about redistribution and how to predict what that ante-mortem before death blood drug concentration was. That's again why there has to be great caution, particularly in individuals who are taking a drug for a long time. So if an individual is taking a drug like citalopram to treat depression for months or even years, there begins to be a depot, meaning a collection of or deposit of drug in the body and all throughout the body. So that increases the likelihood of redistribution.
If somebody had been prescribed citalopram for approximately 50 months prior to their passing, I guess that's improper grammar, his or her passing, would that 50-month time frame be what you're talking about?
Yes, that's more than 4 years.
And so when you talk about it builds up, where does it build up in the body?
It's stored in the tissue, so in the muscle, in the organs, in the vessels, in the blood. And it's not that the individual is going to become toxic because of it. Certainly they do become tolerant to the drug, and that's why when individuals begin to take this drug or other drugs, you start with a small dose and you increase and escalate the dose until you have a therapeutic effect. But repeated administration of a drug leads to accumulation of the drug in the body, and it will take days or weeks to rid the body of all of that drug.
Now, you said earlier that there's some tissues with some drugs that, there's certain parts of the body that they favor to be stored in. Is there any sort of that phenomenon with citalopram?
Not that I'm aware of.
All right. And so, hypothetically, if 840 nanograms per milliliter were ante-mortem value, is that considered toxic?
I would be concerned.
All right. And tell us about your concern.
Well, it's higher than therapeutic in a living person, and I emphasize the term living person. What those effects might be, hard to say. Citalopram is a very safe medication. It would be very difficult to overdose and die as a result of consuming even an entire bottle of citalopram, unless it was a 90-day supply, for example.
All right, so we'll get to that. Now, again, with the caveat or warning that you, a doctor, nobody can really say what the particular effects or side effects any particular person would be experiencing at any particular time. Based on these studies that they've done on citalopram, what are some of the effects that one can observe, generally speaking, in this population study of people that are taking it at the prescribed level that they're hoping to sell?
At the prescribed level, or?
Yes, we'll start with the prescribed level.
Yeah. Very little side effect. It's very well tolerated. We do know when you begin to take medications that are acting on the central nervous system, you have to be very careful about operating your motor vehicle, for example, or working, or if you operate heavy machinery at work. So you need to be careful about that, at least for a few days. But citalopram is a drug that's tolerated very well by many people. And it's a drug that is really not very toxic.
And did these studies show that it had any intended effect of making people seem more happy?
Yeah, I'm not sure I would use
less
that.
depressed, I mean.
Yes, less depressed, and the mood is stabilized, okay. Yes.
Now let's start talking about, as you take more than is intended, what are the side effects that can be seen in people, although you can't say it was in any particular person?
The most common side effects are sedation and the lethargy, and it could lead to death, of course, if too much of it is ingested. But even those side effects are typically not lethal. So people who ingest too much citalopram recover.
And are there any other side effects such as hostility, aggression, irritability, hallucinations?
There can be. There's some rare reports of that in the literature.
And that's what I was going to ask you about, is the frequency of those as compared to the lethargy and sedation.
I would say the frequency is less than just this feeling of sleepiness or lethargy.
And as we get closer and closer to a level of citalopram that might kill you, and correct me if I'm wrong, it might cause respiratory stopping. Is that how it kills you if you take too much?
Yes, you'd fall into a coma. There would be depressed physiologic function, so loss of respiration, hypoxia, anoxic injury to the brain, and death.
And as we get closer to that level, is there any change in the frequency or the list of side effects that we've been discussing as you get closer to the toxic level?
Well, those physiologic changes, obviously, that result in death. But again, it's still primarily a depressant on the central nervous system.
Okay. Now, you mentioned something about injury to the brain. Well, what are you talking about? How does that occur by taking too much citalopram?
If you have loss of respiration, you're not breathing, then the blood no longer carries oxygen. So there's a hypoxic injury to the brain. That's when it's starved of oxygen, and then anoxic injury, which is then typically lethal.
Are you familiar with excuse me, a term called edema?
Yes.
And what is that? Can you tell everybody?
Edema is swelling. You can have edema in a variety of organs, including the brain.
Can citalopram cause edema or swelling of the brain if it's taken at a certain amount?
If an individual overdoses from citalopram and the progression of the overdose is slowed, which it typically would be, it wouldn't be like an instant death like you might see in an opioid overdose. The individual will fall unconscious and slowly die through this progression. Then you do see swelling of the brain.
And is there ever any nausea or vomiting attributed to this path towards taking too much citalopram?
Only early on, and that's just simply by the nature of introduction of too much drug into the stomach. You, of course, become nauseous. And that's true with many drugs, aspirin or Tylenol or naproxen or other prescription drugs. If you insult the stomach with all of this drug, this chemical, you do become nauseous and you might vomit.
If someone were to attribute edema or swelling of the brain, injury to the brain, to citalopram, what other phenomenon would you expect to be able to have observed in that person?
You also likely see pulmonary edema, which is fluid in the lungs, either grossly or under the microscope.
How about behaviors people without microscopes and slides can see?
What might you see? Well, the individual would be unconscious. When the brain swells and becomes edematous, the person is unconscious. It's not consistent with life.
Okay. Now, let's talk about the relationship, if any, between citalopram and ethanol. Is there any relationship, and what can you say about this?
I would say very little once the individual is acclimated to the effects of citalopram. So I'm sure of all the hundreds of thousands or millions of people that take citalopram every day, many of those people are drinking alcohol as well. Now, while you need to be cautious, just to be smart about how much alcohol you consume and the prescription drugs you take, the effect, I would say, is minimal. Of course, you have the effect of the alcohol, but that citalopram doesn't really contribute much to the sedative or central nervous system depressant effect of the alcohol. This is in comparison to the trazodone, because we know trazodone is a sedative. In this case, the citalopram doesn't act as a sedative.
What if we were to dial up the citalopram from the therapeutic 9 to 200 nanograms per milliliter up to 840 nanograms per milliliter, in addition to 0.11 grams per deciliter of ethanol, with, again, the caveat that nobody can state what any one particular person would be under, the effects they'd be under. What could you generally speak about with that?
Generally, I would expect to see increased depression of the central nervous system, so more likelihood for feeling sleepy and lethargic, probably less likely to be able to walk straight, and maybe the individual might stumble.
How about fine motor skills that involve the use of the hands?
You would likely lose that.
Would you expect hostility, aggression, hallucinations, those sorts of things when the citalopram is dialed up to the 840 nanograms range coupled with 0.11 ethanol?
I think the frequency of that is very low. Anything's possible in the world.
Absolutely.
But I think the frequency of that is not likely. The predominant effect is going to be the central nervous system depressant effect, alcohol plus the drug. Agitation, I would say, is less likely to be present.
All right, now let's go through the process of how one takes some citalopram and it starts going into the tissue to hopefully have its intended effect of being an antidepressant. Take us through that process.
So citalopram is available for all oral use only, so it be ingested as a tablet, typically 20 milligram tablets. They may come in smaller tablets as well. So it would be ingested.
Good morning, doctor.
Good morning.
We've met?
Yes, we did this morning.
I want to talk about the things we agree about.
Sure.
We agree that Mrs. Ward was taking Celexa for a long period of time.
Yes.
5 years?
I think it's 50 months. That's not 5 years. I don't have her medical records.
Let's say 50 months. Have you looked at her medical records?
I have not.
Okay. But you're aware that she had been taking Celexa, citalopram, for 50 months.
Yes.
And you're aware that she was prescribed the Celexa, citalopram, for depression.
Yes.
And we agree that the dose Mrs. Ward was taking was on the high level of dose.
Yes.
And we agree that Mrs. Ward had citalopram in her system when she died.
Yes.
We agree that Mrs. Ward's blood alcohol level when she died was over the legal limit.
Yes.
And we agree that you don't know what the effect that alcohol had on Mrs. Ward that night.
I have no idea.
We agree?
Yes.
We agree that you don't know what effect the citalopram had on Mrs. Ward that night.
No, not necessarily.
Okay, you know what effect that Celexa and that citalopram had on Mrs. Ward on September 21st, 2009.
I don't think we have evidence that she was overdosing or succumbing to the toxic effects of the citalopram on that day.
Doctor, has anyone ever suggested that Mrs. Ward overdosed?
No.
Okay, so my question to you is, you don't know what effect the citalopram that you've acknowledged was in her system, you don't know what effect that had on Mrs. Ward on September 21st, 2009.
I don't know the effect, but I don't have any evidence per se that would suggest that she was having issues with the drug.
One way or another.
That's right.
So you don't know,
Yes.
correct?
Yes.
Is alcohol a central nervous system depressant?
Yes.
Does alcohol reduce inhibitions?
Yes.
Is one of the noted side effects of Celexa citalopram in excessive doses aggression,
Potentially.
hallucination,
Maybe.
possibly?
Possibly. Yes.
And patients are told not to drink while taking citalopram, correct?
They're cautioned about it.
Doctor, thank you. That's all I have.
Redirect.
No, thank you. You can be excused.
Mr. Ellsworth, is this witness be excused?
Yes, Your Honor.
All right, thank you, Doctor. Free to go.
Thank you.
The jury in the Bob Ward trial is still deliberating in Florida. They were expected to run until about 6 o'clock tonight. We're 5 minutes away from that. We're going to wait and see if the judge comes back in to send the jury back home for another day of deliberations tomorrow. Jonna Spilbor remains with me here at the Law&Crime Network. We just listened to testimony from a forensic scientist, and keep in mind this was a state expert. And I think the defense still got in some really good shots at this guy. He said in the state's case in chief, well, you know, we don't know how bad the alcohol could have affected this particular victim. She might have had tolerance to it. You know, the antidepressant she was on is very safe. It's almost impossible to overdose on it. It builds up in the body, so she'd been on it for a while. It might account for the elevated amounts of it. It might not really be an overdose. You put them together. He said it's hard to say what the effects would be. Well, you know, the defense has clearly read the drug warnings and hits at the guy and says, well, it can cause aggression. Well, yeah, maybe it can. It can cause hallucinations. Well, yeah, maybe it could. And I mean, this expert almost testified out of both sides of his mouth.
As experts often do, especially when they're subjected to a really good cross-examination. And we have to remember one thing here. The defense does not have to prove beyond a reasonable doubt that this drug combined with this amount of wine is going to cause this effect. They just have to be able to convince the jury that it's plausible that that happened, because if it's plausible, then there is reasonable doubt that the state is going to be able to prove its case. And I think the defense really did a great job here at that, because they, like I said, it's not their job to prove anything, but they give enough fodder to the jury that some of them have to be sitting back and saying, that could have happened that way.
I'm sitting here saying that, and I would like to think that I'm a reasonable person. I think you're sitting here saying that too.
Oh, absolutely. And
not that I'm a reasonable person, but that this could be a
not all the
plausible
time.
defense.
Right, exactly. And that's, I mean, and that's really all the defense has to put forward. They don't have to prove a darn thing, but they do a really good job at giving the jury something to really chew on. That this was not simply what the prosecution has put forth: angry fight, husband, pull the trigger on purpose, wife dead. The defense has really put the brakes on that and said, no. Here are a couple of other theories that could have happened here.
This was a strong cross-examination in part because of the trial tactic. Short questions, closed-ended questions that call basically for a yes or no answer, questions that are loaded with a lot of research and a lot of information. This defense attorney did homework and was able to go after this guy with just the right key facts.
Oh, absolutely. And I'm sure that the reason the defense attorney was able to do that, because the defense attorney is not a forensic scientist or a doctor, is because it had its own expert to help provide information and fodder for cross-examination for this particular expert. And you know, as well as I know, that a really great cross-examination isn't, you're not asking questions at all. You are giving statements and you're making them appear as though they are questions, but they are not. They are statements that you want the jury to believe and understand, and you just happen to be bouncing them off the person that's in that witness chair. But you're not asking them to espouse anything, especially on cross-examination. It's yes or no.
Precisely. It looks like we're starting to get activity in the Bob Ward courtroom. They were expected to wrap up, send the jury home here very shortly. So that is probably what they're coming back in for. The jurors asked to have the gun back in the jury room. Yeah. That requires a little bit of extra security. But look, jurors want to handle this thing and see what it's all about. You know, is this a heavy gun? Is it a light gun? Is it the sort of gun people could plausibly struggle over? Right. Is it not? Is it a smooth surface or is it a rough surface? What's the handle made out of?
Is there a safety or not a safety?
Exactly. These are all things that people want to know. If the handle is more rough, is it possible more DNA could transfer? Because the amount or lack of DNA on it has become an issue in this case.
That is correct. I think that gun is the biggest piece of evidence, however, in the case, and they went for that very early on in their deliberations. Very important to them. I wouldn't be surprised if you... Again, we're not going to be in the jury room if they try to reenact a struggle with that gun to really get a handle on, could this have happened the way the defense purported it to, or did it happen the way the prosecution purported it to?
And if there's a question, of course, that means there's reasonable doubt in a strict read of the law.
Absolutely. And that would be a win for the defense here, especially since, as we discussed earlier, this is the second trial for this defendant. If they come back with anything other than another conviction, it might be the end of the road for this defendant. Even if there's a hung jury, there might not be a third trial.
The state's been careful this time around because the state botched the case the first time around. This is the second trial. If you're just joining us for this defendant, the first one was turned around, and it was turned around on a couple of grounds. There were complaints about defense counsel not raising proper objections. Now, interestingly enough, Florida is really tough on that. I've seen other states where this gets raised on appeal and the court just turns around and says, oh, I don't think that really mattered to the jury. And that bothers me because, look, I mean, if your attorney isn't lodging the right objections to evidence, then the jury is hearing anything that may or may not be accurate. And look, of course that influences the case. But I've read opinions in some states that I won't name right now. People who have been watching us for a long time have probably heard me complain about them. But, you know, Florida latched onto that, but also the state was commenting on the defendant's right to remain silent. Right. Prosecutors can't do that.
No, and I wouldn't be surprised if the prosecutor did it on purpose to see if the defense attorney was on his or her toes the first time around, and that happens, which is why you do have to be on your toes. But some appellate courts will find mistakes of that nature harmless error, and if they don't believe that it would have changed the outcome of the case, then cases don't get overturned, and you don't get a new trial. Obviously, that didn't happen here.
It looks like we're going back into session in the Bob Ward case. Let's listen back into court.